Vice President.
Let us pray. Almighty God, we willingly acknowledge you as the Supreme Being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
So this will help you.
Oath or affirmation. Announcements by the President.
Vice President. Honorable Senators, I wish to advise that the President of the Senate, Senator the Honorable Christine Kangaloo, is currently out of the country. Honorable Senators, leave of absence has been granted to Senator Ronald Huggins, Senator Anita Haynes, Senator Stephen Creese, and Senator Melissa Ramkisoon, all of whom are out of the country, and to Senator Torel Shrikisoon, who is ill. Honorable Senators, I have received the following correspondence from Her Excellency the President, Paula May Weeks. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula May Weeks, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Mr. Ndali Young. Whereas Senator the Honorable Christine Kangaloo is incapable of performing her duties as the President of the Senate by reason of her absence from Trinidad and Tobago, and the Vice President of the Senate is required to perform the duties of the President of the Senate. As a result, a vacancy has arisen in the Senate. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44 of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ndali Young, to be temporarily a member of the Senate with effect from the 21st of June 2018 and continuing during the absence from Trinidad and Tobago of Senator the Honorable Christine Kangaloo, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 20th day of June 2018. To Mr. Gavin Simonet, whereas Senator Ronald Huggins is incapable of performing his duties as a senator by reason of absence from Trinidad and Tobago, now therefore I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Gavin Simonet, to be temporarily a member of the Senate with effect from the 21st of June 2018 and continuing during the absence out of the country of Senator Ronald Huggins, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 21st day of June 2018. To Ms. Haseen Sheikh, whereas Senator Anita Haynes is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago, now therefore I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Haseen Sheikh, to be temporarily a member of the Senate with effect from the 21st of June 2018 and continuing during the absence from Trinidad and Tobago of Senator Anita Haynes, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 21st day of June 2018. To Mr. John Heath, whereas Senator Melissa V. Ramkisoon is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Mr. John Heath, to be temporarily a member of the Senate with effect from the 21st of June 2018 and continuing during the absence from Trinidad and Tobago of the said Senator Melissa V. Ramkisoon, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 18th day of June 2018. To Mr. Ronald Duke, whereas Senator Stephen Creese is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ronald Duke, to be temporarily a member of the Senate with effect from the 21st of June 2018 and continuing during the absence from Trinidad and Tobago of the said Senator Stephen Creese, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 18th day of June 2018. Honorable Senators, Senators are required to take the oath. One more? I'm sorry, there's one more. Pardon. I'll have to read that one out. Oh, there we go. All right, to Ms. Zola Phillips, whereas Senator Torrell Shrikissoon is incapable of performing his duties as a senator by reason of illness, now therefore I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Zola Phillips, to be temporarily a member of the Senate with effect from the 21st of June 2018 and continuing during the absence of Senator Torrell Shrikissoon by reason of illness, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 21st day of June 2018. Honorable Senators, Senators are required to take the oath.
I and Galleon, having been appointed a member of Parliament, do solemnly affirm that I would bear true faith and allegiance to Trinidad and Tobago and will uphold the Constitution and the law. I will conscientiously and impartially discharge the responsibilities of the people of Trinidad and Tobago upon which I am about to enter.
I, Garvin Simonet, having been appointed a member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Hussein Sheikh, having been appointed a member of Parliament, do swear by Almighty Allah that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, John Heath, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Ronald Duke, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Zola Phillips, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Bills brought from the House of Representatives, petitions, papers.
Minister in the Ministry of Finance.
Thank you, Mr. Vice President. Mr. Vice President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Minister of Finance. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Tobago Regional Health Authority for the years ended September 30, 2011 and 2012. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Princestown Regional Corporation for the year ended September 30, 2015, and the annual parent and consolidated audited financial statements of Point Lisas Industrial Port Development Company Limited for the year ended September 31, 2017. Thank you, Mr. Vice President.
Reports from committees, urgent questions.
Senator Mark.
Thank you, Mr. Vice President. To the Minister of National Security, in light of the recent murder of a woman who was a victim of domestic abuse and had been granted a protection order by the courts, are the authorities reviewing the mechanisms available for victims of abuse to obtain the protection of the state?
Minister of National Security.
Thank you, Mr. Vice President. Mr. Vice President, mechanisms are always subject to review. And with respect to persons who are granted protection under the court, the Trinidad and Tobago Police Service continues to monitor and liaise with the individuals at random times. Also instruct them in case there's a breach of that order to notify the police as quickly and as soon as possible so the police can take the necessary action. But also, Mr. Vice President, I want to add that with respect to persons who are protection under the court, there's also a need for us as within the community, within the society, to be able to support those people and to be a sort of a support to them in the various areas and community, because the police can't do it alone, but we expect that the community would also give them the necessary support with respect to those type of situations. Mr. Vice President.
Senator Mark.
Thank you, Mr. Vice President. Can the Minister indicate whether the government intends to introduce legislation to protect women, 50 of whom have been murdered in the last year?
Minister of National Security.
Mr. Vice President, the government is in fact working on amendments to the Domestic Violence Act, which in fact have never been done before. But this government is doing that as we stand right now, Mr. Vice President.
Senator Mark.
Mr. Vice President, in light of the situation facing women in this country, can the Honorable Minister provide some time frame when legislation amending the Domestic Violence Act will arrive in this Honorable House?
Minister of National Security.
Mr. Vice President, we hope by September we should have some advancement in that regard. But we're working in tandem with the Family and Divisions Act. In fact, we have amended the Family and Divisions Act.
Senator Mark, next question.
To the Minister of National Security. In light of reports that a list of names, photos, and addresses of gang members have been leaked onto social media by members of the police service, has the Trinidad and Tobago Police Service launched an investigation into said reports?
Minister of National Security.
Vice President, yes.
Senator Mark.
Could the Honorable Minister indicate when this report will find its way in the public domain, given the seriousness of the matter before us?
Minister of National Security.
Mr. Vice President, I cannot say that that report will find its way to the public. Depending on the nature of the report and the findings of the report, it may take a different route. I, Commissioner of Police of the DPP, so I cannot say it will be made to the public.
Senator Mark.
What action, Mr. Vice President, does the Minister, through the Commissioner of Police, intend to take with these rogue police officers who misuse their office, abuse their office, to do such things as we are discussing at this time? Could you advise this Honorable House what action you intend to take as the Minister of National Security to root out these elements?
I will not allow that question. Next question, Senator Mark.
To the Prime Minister. Having regard to reports that the body of the murdered 33-year-old mother of Dondonald Hill, Debe, was discovered by her two young children, no pun intended here. Has the Children's Authority arranged for the care and counseling of said children?
Minister of Communications.
Thank you very much, Mr. Vice President. Mr. Vice President, on behalf of the government of Trinidad and Tobago, we extend our greatest condolences and sympathy to the family that has had to go through this very traumatic incident. And in fact, we're quite disturbed that an attempt is being made to politicize it. Nevertheless, and nevertheless of the poor jokes from the other side, the government says that the victim and witness support are the first responders. They did immediately remove the children and provided counseling support. The Children's Authority, the Children's Authority are now involved and are assessing the children's long-term care. The children, thankfully, are safe with their grandmother, and the government will continue to provide as much support as is needed and as is possible. And the Children's Authority is following up. Again, we extend our sincerest condolences and sympathy.
Senator Mark.
This is not a political matter, Mr. Vice President. I want to advise the young man that this is not a political matter.
Senator Mark, question. What's the question? What's the question?
My question to the Honourable Minister is simply this. Could you advise this Honourable Senate what specific measures have been effected by the Children's Authority to deal with the trauma that these young children have experienced as a result of this development? Could you share with us?
Minister of Communications.
Thank you very much. Once again, we're dealing with young children who have just gone through a very traumatic experience. And we do not encourage that what they're going through become the national conversation, as is being attempted to be done here. As is with all of these types of help and assistance that they get, it is confidential. We feel confident that the Children's Authority is doing all that they can with the experts that are available, and we cannot provide any specificity as to what is taking place, but we know they are providing counseling, they are the experts, and we will continue to support them despite what is happening on the other side.
Senator Mark.
Mr. Vice President, could the Minister indicate whether these children will be exposed to psychological, emotional, counseling as it relates to that very unfortunate experience that they have gone through? Whether this Children's Authority will be addressing those elements of needs of those children at this particular time, the psychological care, the emotional care that is required at this time, which is part of the arrangement.
Senator Mark, that question has been answered by the Minister of Communications. So, next question, please.
I don't think he answered, you know, sir.
Next question, Senator Mark.
Okay, Mr. Vice President, I shall be guided. To the Minister of National Security. In light of recent reports that persons dressed in police uniform attempted to carry out a robbery in central Trinidad, what systems exist in the Trinidad and Tobago Police Service for officers to account for uniforms issued to them?
Minister of National Security.
Thank you, Mr. Vice President. Mr. Vice President, in keeping with the Trinidad and Tobago Police Service standing orders, there's a system in place with respect to verifying the uniform worn by members of Trinidad and Tobago Police Service. There's, in fact, periodic kit inspection. The uniforms themselves are marked and registered to the officers. They're marked with indelible ink. There's also random checks taken by supervising officers. Mr. Vice President.
Senator Mark.
Could you explain this situation to this Honorable House? How did these bandits arrive at having these uniforms, purportedly police uniform? Can you explain that, and could you indicate whether you are going to launch an inquiry into this matter?
I will not allow that question, and that is the end of urgent questions. We have come to the end of that 10-minute period.
Questions on notice. Questions for oral answer.
Mr. Vice President, the government is pleased to announce that it will be answering questions number 137, 150, 151, 174, and 175. We ask for a 2-week deferral of question number 152.
Number 152, Leader of Government Business?
Yeah, 152.
Okay. Question number 152 will be deferred for 2 weeks as per the standing order. Senator Mark, question number 137.
Yes, thank you, Mr. Vice President. Question 137 to the Minister of, is it Finance or Works and Transport? Okay, okay. Question number 137 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Mr. Deputy Speaker, and thank you for the question, Senator Mark. The vessel arrived in Cuba on May 26, 2018. Prior to its arrival in Cuba, a team of persons representing both the buyer and the seller arrived in Cuba on May 15, 2018, in order to expedite the shipyard work. However, the seller experienced difficulties transporting some of the required materials and equipment from Australia to Cuba. As a consequence, the government of Trinidad and Tobago has taken a decision to bring the vessel to Trinidad from Cuba at the earliest practical opportunity and to have the work done here in Trinidad. Upon its arrival in Trinidad, time must be allowed for the reflagging of the vessel, familiarization of the crew with the vessel, and the type rating of the crew, after which it will be put into service. The proposed enhancement will be done on a phased basis while the vessel is in service. I thank you, Mr. Vice President.
Senator Mark.
Vice President, could the Honorable Minister of Works and Transport tell the population when will the so-called Galleon's passage arrive on the shores of the Republic of Trinidad and Tobago? Can you give us a specific date? Because it's right there in Cuba. So you need to tell us when that ship is going to arrive here.
Minister of Works and Transport.
Mr. Vice President, if I could predict the exact date of things that I don't have control over, I would not have been here today. Mr. Vice President, I just want to repeat my answer. As a consequence, the government of Trinidad and Tobago has taken a decision to bring the vessel to Trinidad from Cuba at the earliest practical opportunity and to have the work done here. I thank you.
Senator Mark.
Mr. Vice President, can the Honorable Minister indicate to the Senate whether the government of Trinidad and Tobago, when they entered into that arrangement to purchase that vessel, was not aware that Cuba was under a full and total embargo? Was the government not aware of that embargo before they took that decision to agree with the seller to go to the Galleon shipyard? Could you explain to this Honorable House?
I will not allow that question. Next question, Senator Mark.
Mr. Vice President, could the Honorable Minister indicate to this Parliament, seeing that this boat is not going to be here for a long while, can he indicate to us what was the cost to the taxpayers of this country whilst that boat was located in the Galleon shipyard for 31 days? Did the seller absorb that price or cost, or was it absorbed by the taxpayers of the Republic of Trinidad and Tobago? Could you explain to us, sir?
I will not allow that question. Next question, Senater Mark.
Well, I don't know which one you'll allow because I've asked twice.
Senator Mark, next question, please.
Okay. Okay, listen. This is a democracy, you know. This is not a PLM party group, you know.
Senator Mark, take your seat.
Sorry.
Take your seat. When I call on you to ask the next question, just do so. No comments, just...
Seek your protection, sir.
When I call on you to ask the next question, just do so.
I will, but I seek your protection.
Just do so. You will always have my protection. Just ask Senator Mark.
All right, I'll be guiding you. Can I ask my question?
You are reminded that there is a specific time period for these questions as it relates to the order paper. Every time I have to raise to my feet to guide individuals, that time is running. Next question.
Can the Honourable Minister indicate what would have been the practical difficulties experienced by the shipyard owners in bringing the Galleon passage up to speed after 31 days? Could you explain to us?
Minister of Works and Transport.
Thank you. Thank you, Mr. Deputy Vice President. Mr. Deputy Vice President, it was said on several occasions in this House and the other House that the agreement for the purchase of the Galleon passage was done where the seller had certain responsibilities to fulfill, and also the buyer had certain responsibilities. The seller had an arrangement with the Damin shipyard in Cuba, and the seller chose the Damin shipyard to have their part of the sale completed. The sellers found difficulties. The government of Trinidad and Tobago can wait no longer for the boat to reach here, and the government of Trinidad and Tobago have taken a decision to bring the boat to Trinidad, and we will have the retrofitting done here. The cost that the seller has to incur will be incurred by the seller, and the retrofitting that the government of Trinidad and Tobago had planned to have done at the same time will be done here, and that cost will be borne by the government of Trinidad and Tobago. I thank you.
Vice President, may I?
Supplementals are ended on this particular question. Next question, Senator Mark.
Yes, Mr. Vice President, is 150, I believe, sir? Is 150?
150, yes.
Question number 150 to the Minister of National Security.
Minister of National Security.
Thank you, Mr. Vice President. So, Vice President, there has been no reduction in the supply of fuel to the Trinidad and Tobago Defence Force, Coast Guard in particular. Similar to other public agencies, Trinidad and Tobago Defence Force will sometimes be impacted during the processing and management of scarce financial resources, in which case they will prioritize their missions and their operations accordingly, Mr. Vice President.
Mark?
Vice President, through you, can the Minister indicate when these news or information is issued by the media? Can I ask the Minister, through you, Mr. Vice President, why couldn't the ministry issue some clarification on this matter? Because we were told that
Senator Mark, just a question. Just a question. Yes. So, yeah. Minister of National Security.
Mr. Vice President, there is no need for that response to the media because the media prints a number of things. I can't respond to everything that the media prints. As far as I'm aware, from the government standpoint, the government is prepared to provide all the necessary resources for the agencies of national security to do their job effectively and efficiently. And we so do, Mr. Vice President.
Minister, can the Honourable Minister indicate whether during the last few months the Coast Guard experienced challenges in fuel supplies for their vessels? Can you clear the air for this Honourable Senate on this matter?
Minister of National Security.
Mr. Vice President, what I asked, what do you mean by challenges? I just said to you that there has not been any reduction in the supply of fuel to the Trinidad and Tobago Defence Force, Coast Guard in particular. What do you mean by challenges?
Senator Mark.
What's the next question?
151.
Yeah. Question number 151 to the Minister of Education.
Minister of Education.
Thank you very much, Mr. Vice President. The very easy response to this question is that this initiative is ongoing and therefore it is permanent. Thank you.
Mark.
Can, Mr. Vice President, can the Honorable Minister indicate whether the effect of having the community police unit assist in this particular project, can the minister indicate whether the results are positive in terms of reductions in this regard?
I will not allow that question. Next question, Senator Mark. Next supplemental, if you have
What
another one.
impact, if any, is the engagement, Mr. Vice President, the community police unit is having on school violence in the various schools?
Minister of Education.
Thank you very much, Mr. Vice President. I am pleased to report that the police community unit has been having very positive impacts where these schools are concerned, because they are engaged not only with the students and the teachers, but also with the community. And as a result, we have seen a marked reduction in the incidence of indiscipline and violence in our schools. Thank you.
Senator Mark.
Mr. Vice President, can the Honorable Minister share with the Senate which schools are really benefiting from this particular project? Can you share with us the schools that are benefiting from this project?
Senator Mark, I won't allow that question. Next question, Senator Mark.
Do I have another one, sir?
That one is deferred. That one is deferred.
I think that's the one.
Oh, Senator Amin, sorry.
Yes.
Senator Amin. Question 174.
Thank you very much, Mr. Vice President. Question number 174 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Mr. Vice President. Mr. Vice President, along the Dock Road area, the port police officers are dispatched to assist with traffic management. These officers have no jurisdiction along Rising Road and liaise with the TTPS, which renders assistance. Dredging of the harbor is expected to begin in late September for a duration of approximately 2 months. Once this dredging of the harbor is completed, the GSS jetty becomes accessible and operational, which will cease the operations at Berth 3, where they are carried out at present. All cargo operations will return to the GSS jetty. This will eliminate the traffic pileup caused by the queue for trucks bound for Tobago. I thank you.
Senator Amin.
Mr. Vice President, I thank the Minister for his response, but I want to ask, in the interim, between now and September, when the new facility will be available, in the interim, what arrangements are in place to manage the traffic pileup that understandably happens?
Minister of Works and Transport.
Thank you. Mr. Vice President, this has been happening since 2013. What the port have put in place is, with the assistance of the TTPS, is to have regular police patrols and seek assistance from the TTPS for the Rising Road area. Thank you.
Senator Amin.
Madam, Mr. Vice President, is the Minister willing to guide the port to have any sort of consultation or talks with the operators or truck drivers with the view of improving the system? Will they be open to that?
Minister of Works and Transport.
Mr. Vice President, the challenge at the port is the trucks bounded for Tobago is loaded at Berth 3. The port at Port of Spain do not have the capacity to have all these trucks parked on the compound and then to be loaded on the vessel. So there isn't much that can happen between now and the completion of the dredging to have the vessels loaded back at the GSS jetty. However, what can be put in place is more consultations with the TTPS to have some more patrols on the road. But there isn't much that can be done at this point in time, because trucks, the vessel has a time to leave, to arrive in Tobago at a certain time. And the vessels has to be loaded, and you can only load in a certain format. Thank you.
Mr. Vice President, question 175, again to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Mr. Vice President. Mr. Vice President, the Ministry of Works and Transport under the Pure Unit has a number of projects planned which include the widening of the Uriah Butler Highway in a phase from the Chaguanas all the way down to Golconda to 3 lanes. As such, the medium, which occupies the space between the north and southbound lane of the highway, will be needed for the road widening. When this road widening occurs, the cable barrier system will not be the most suitable option since there will be no room in the median. Therefore, a rigid barrier system such as the slip-form New Jersey barrier system will be the best suited and needed to divide the highway network. I thank you.
Senator Amin.
Mr. Vice President, can the Minister indicate, I know you called out some parts of the highway, can you indicate if it is the entire length or which parts of the highway you're going to have these? The widening, you indicated that with the widening, you're not going to replace the cable barriers, you're going to put New Jersey barriers. But there are other parts of the highway where the cable has been damaged and it takes repair or replacement. Since not the entire length of the highway will be widened, I just want to ask
him the question,
the Minister, which parts are going to be widened and if the other areas, the cable barrier is going to be repaired.
Minister of Works and Transport.
Mr. Vice President, the question kind of varies from the original question. However, just to bring some clarity, what I said is that we have a lot of planned projects, and this will be done on a phase basis. If you want to know what we're doing immediately with the cable barriers, the immediate plan is to have the cable barriers replaced. The long-term plan, to have them repaired. The long-term plan is to have them replaced in areas where they will no longer be needed. Thanks.
Public business, government business, bills second reading.
The debate on the second reading of the following bill, which was in progress when the Senate adjourned on Thursday, June the 14th at 2018, will be resumed. A bill entitled An Act to Make Jurisdiction for Criminal Matters Exercisable in a Division of the High Court to be known as the Criminal Division, and to make jurisdiction for criminal and traffic matters exercisable in a division of summary courts to be known as the District Criminal and Traffic Courts, and to make provision for matters connected therewith. The list of those who spoke last Thursday, June 14th, is the Honorable Faris Alwari, MP, Attorney General, mover of the motion, Senator Anita Haynes, and Senator H.R. Ian Roach. Minister of Labour, Small Enterprises.
Thank you very much, Mr. Vice President, for the opportunity to participate in this debate on the Criminal Division and District Criminal and Traffic Court Bill 2018. This is a bill to make jurisdiction for criminal matters exercisable in a division of the High Court to be known as the Criminal Division, and also to make jurisdiction for criminal and traffic matters exercisable in a division of summary courts to be known as the District Criminal and Traffic Courts, and to make provision for matters connected herewith. Mr. Vice President, the pervasiveness of crime in our beloved nation undoubtedly causes great distress, not only to me on a personal level, but I'm quite sure to all my colleagues here in this chamber and the rest of Trinidad and Tobago. Mr. Vice President, how can one not be distressed by the increasing frequency of the crime, the incomprehensible ruthlessness that we see being displayed through various forms of criminal acts, the increasing bold-facedness of the criminals in this country, the cries of the parents, in particular the mothers like myself, who have become victims of crime. As a mother myself, Mr. Vice President, I am really tortured by the realities in which we live. The merciless public beating of a woman recently in a car park in a mall in Marabella some time ago, closely followed by the way killing of teenager Eric Garnish in Princestown a few Saturdays ago, continues to haunt this country, Mr. Vice President. Undoubtedly, this House would agree that many precious lives have been lost to crime. And today, as I stand in this honorable House, I am certain that all of us, citizens of this country, will support the passage of this critical piece of legislation, the Criminal Division and District Criminal and Traffic Courts Bill 2018. Mr. Vice President, the Trinidad and Tobago Police Service 2017 crime statistics shows a 5.5% increase in overall criminal activity as compared to 2016. In 2017, Mr. Vice President, 1,064 firearms were seized, and there were 496 murders. And there was also a detection rate for murder of 17.95%, an increase from 15.2% in 2016. Mr. Vice President, the United States Department of State Overseas Advisory Security Council, in its Trinidad and Tobago 2018 Crime and Safety Report states, and I quote, "In Trinidad, the majority of violent crimes, homicides, kidnappings, assaults, robberies, sexual assaults, are gang or drug-related or domestic in nature. A significant growing portion is attributed to the influence of gang, illegal narcotics, and firearms," close quotation marks. Mr. Vice President, the government has been entrusted by the people of our beloved country to lead. And we have been doing so. We have been working hard, taking concrete measures to address the serious crime situation that we all face in Trinidad and Tobago. A crime situation which, may I remind, did not start yesterday or the day before that, but long before this government came into power. I have time and time again, Mr. Vice President, highlighted that this government does not shirk its responsibility or its duty. It acts even when the mountains before us seems quite insurmountable. I want to look briefly, Mr. Vice President, at the criminal justice system. I'm certain that this House is mindful of the hard work which the Honorable Attorney General has put into bringing a suite of legislation to improve the criminal justice system in this country. I myself have contributed to the debate on the Anti-Gang Bill 2018 and the DNA Regulations 2018. And once again, I must commend him for his efforts and note, Mr. Vice President, that we are here today because of the Attorney General's determined efforts to make meaningful and effective changes to our criminal justice system for the benefit of all of us. Mr. Vice President, the judiciary is a fundamental part of our criminal justice system. As outlined in the House of Representatives by the Honorable Attorney General, the criminal justice system requires the following elements to be in place. We need a judge, we need a court, we need evidence, we need a prosecutor, we need a defendant, we need the police who provide the ancillary services to be there. We need a prison service, Mr. Vice President, who also provide ancillary services. We need the Forensic Science Center, which provide ancillary services to cooperate. We need the rules of the court. We need the financing arrangements, and we also need the laws. Mr. Vice President, within Trinidad and Tobago, criminal matters before the High Court start with the preliminary inquiry, where you go before the magistracy, you present your arguments and your evidence before the magistrate, who would then determine whether there's a prima facie case or a case which is good enough to go for trial to the High Court from the to the High Court in the assizes. You begin the trial in the High Court in the assizes. From the assizes, you go to the Court of Appeal. And from the Court of Appeal, as we have seen often time and time again, you go to the Privy Council. Mr. Vice President, the criminal justice system is filled with complexities and nuances that may not always be easily clarified, but it is pellucidly clear to all of us, criminal law expert or not, that the pace of justice in this country needs significant improvement. Mr. Vice President, we need to improve judicial capacity. We need more courts. We need rules to govern those courts. We need to improve our prosecutorial system. And we need more lawyers at the criminal bar. Mr. Vice President, I wish to remind this House of the contribution, once again, I quote the Honorable Attorney General, on the debate of this bill in the House of Representatives on April 13, 2018, just over 2 months ago, where the Attorney General identified, and I quote, "The Constitution is the supreme law of Trinidad and Tobago, Section 2 of the Constitution. Under the Constitution, we have the establishment of the judiciary and the Court of Appeal. The Supreme Court of Judicature is, of course, set out under Chapter 7. Under Section 99, straight on to 109, we have the structures of the court in the Constitution. We established the Supreme Court. We established the Court of Appeal. We dealt with the manner of the appointment of judges, and we redefined and reconfirmed that there may be an appeal to the Privy Council. Of course, I will close my quotations of the full statement made by the Honorable Attorney General. Mr. Vice President, the Attorney General has already done an excellent job at putting the information forward. My duty is merely to remind this House of his contribution in that context. Let us look at some of the key clauses of the bill, Mr. Vice President. This bill provides at Clause 4 for the establishment of a criminal division of the High Court, which shall comprise the criminal court, which would enable the court to treat with matters in a more expedient manner. Mr. Vice President, additionally, the matters at Clause 5 and Clause 6, and I would want to quote briefly from Clause 6 for emphasis. Clause 6.1 states, "Sittings of the criminal court shall be held at such locations and at such times the Chief Justice, in consultation with a judge assigned to that court, may appoint in accordance with the Supreme Court of Judicature Act." And provision 6.2, notwithstanding subsection 1, the criminal court may, when required and appropriate, sit at any time and may conduct hearings by telephone, video conference, or any other appropriate electronic means. Mr. Vice President, as such, this piece of legislation enables the court to sit at any time when it is required and appropriate to do so. But more importantly, it gives the court more flexibility conducting hearings by allowing the court to be conducted either by telephone, video conferencing, etc., which is very, very important in this day and age of technological advancement and entrenchment in all of our lives, Mr. Vice President. This provision also has the potential to assist with preventing undue and unnecessary delay in disposing of matters that are before the court, as the court will be granted a broader discretion in treating with matters. Mr. Vice President, furthermore, Clause 7 of the bill provides for the assignment of judges and masters of the criminal court, and these assigned judges and masters would deal specifically with matters in the criminal court. The bill does not simply provide for the establishment of a criminal court, Mr. Vice President, but at Clause 18, it provides for the necessary support structures to be put in place. That is, an administration department to be known as the Criminal and Traffic Court Administration Department. The establishment of such a department, Mr. Vice President, ensures that the criminal division is effectively managed and treated as a priority. That department has a number of units that specifically assist with the management of different areas and duties of the court. So that, Mr. Vice President, this bill also provides for rules of the court to be made at Clause 24 for the purpose of establishing a special procedure for the management of certain types of cases. I cannot underscore the importance of such a provision, Mr. Vice President, as having a special procedure for the management of cases can help streamline more important cases that would ordinarily have to be dealt with at some later date. Mr. Vice President, I want to dwell briefly on the benefits of a criminal court. Mr. Vice President, I would have outlined certain statistics in relation to the state of our criminal justice system, and it is obvious that the volume of work to be completed greatly exceeds the staff available to do so. It is also clear that in looking at criminal matters alone, we are speaking of tens of thousands of cases which have to be dealt with, in addition to the various other cases dealt with by magistrates, masters, and judges. Mr. Vice President, by having a specialized court which deals specifically with criminal cases, it would decrease the burden and workload on the judicial officers. With a decreased workload and more efficient case management, the backlog of cases can be resolved, ensuring that justice is delivered in a timely manner. And Mr. Vice President, we often hear citizens of this country complain bitterly about cases and the lengthy backlog of cases that faced the judiciary in 2018. As a consequence, Mr. Vice President, this country would have one less occasion to sigh, justice delayed is justice denied. Mr. Vice President, a 2013 paper published by the World Bank entitled Developing Specialized Court Services, International Experiences and Lessons Learned. The authors noted that the court specialization was commonly considered to be an important reform initiative to advance the development of a successful judicial system. This World Bank paper emphasized that specialization could be helpful in improving the processing of court cases that are more complex or require special expertise beyond the law. Mr. Vice President, three of the main benefits associated with court specialization identified by the authors as follows. 1. Firstly, there is greater efficiency. Specialized procedures and staff and judges who are well-versed in these cases lead to streamlined operations and more efficient processing of cases. By diverting a class of cases to specialized courts, the burden of growing caseloads in the regular courts will be reduced. also positively impacting on the operations of that court. Secondly, Mr. Vice President, a judiciary of specialists leads to higher quality decisions, especially in complex areas of the law. Their greater expertise and experience will lead to better decisions, better outcomes for the litigants, and greater user satisfaction. And thirdly, Mr. Vice President, the creation of specialized courts with exclusive jurisdiction over particular areas of the law would enhance uniformity of decisions in those areas, thereby contributing to greater predictability and confidence in the courts and possibly reduce appeal rates. Mr. Vice President, I would just like to cite a few international examples of specialized courts. The authors of that paper, Mr. Vice President, the experience of the Land and Environment Court of New South Wales, based in Sydney, Australia, supported the claim of greater efficiency and higher quality decisions. Also, Mr. Vice President, specialized courts that were set up to process different case types according to complexity and to ensure speedy processing, such as the first expedited drug courts in the United States, are another example supporting the assumption that specialization can lead to greater efficiency, particularly if that is one of the aims of specialization and the design is focused on this aspect. Mr. Vice President, in Singapore, there exists a criminal justice division of the Singapore subordinate courts. To improve efficiency in Singapore's criminal division, which handled almost 59,000 criminal charges, over 60,000 traffic cases, and over 128,000 statutory charges and summons in 2012, 7 specialized groups of courts were created. 3 of these groups focus on concentrated processes, such as the Centralized Pre-Trial Conference Court, and 4 groups focus on specific crimes. Mr. Vice President, on speaking on criminal matters and the need for specialized criminal courts, the authors noted that major crime cases, such as organized crime or high-level corruption cases, tended to require special witness or victim protection and handling. These cases also tended to demand special expertise from judges and prosecutors and more effort in preparation, which often meant that judges needed to have the relevant expertise to ensure that witnesses and victim services were in place and procedural timelines were adequate. The authors quoted several examples of specialized criminal courts around the world, including the Sandiganbayan of the Philippines, Mr. Vice President, which was a specialized anti-corruption tribunal. The authors noted that the minor crime cases, such as traffic infringement or the possession of small amounts of illegal drugs, could be handled more effectively, more efficiently, and quickly using highly streamlined, low-cost processes, an approach adopted in many jurisdictions in the United States and other countries. Mr. Vice President, traffic courts in particular are often established as independent tribunals, sometimes distinct from the general courts, for processing very large volumes of, for example, parking fines and other kinds of lower-level motor vehicle and road offenses. Mr. Vice President, right here in the Caribbean, in Jamaica, there already exists a system of specialized courts, particularly at the magisterial level. There's also a traffic court, a gun court, a coroner's court, a drug court, a night court, a tax court, a family court, a juvenile court, and small claims court. And in this regard, Mr. Vice President, Jamaica has been well advanced for some time with many of these specialized courts being established decades ago. For example, the gun court in particular was introduced in Jamaica in 1974, many, many years ago. The drug court in Jamaica is well regarded and has been the subject of very positive reviews, Mr. Vice President. We need only to look to the recent examples of the establishment of the Children's Court through the Juvenile Court project right here in Trinidad and Tobago. Previously, Mr. Vice President, there were no dedicated courts with the appropriate mechanisms and supporting social services in place to ensure speedy and efficient resolution of cases and access to intervention programs for children and families in our beloved Trinidad and Tobago. Mr. Vice President, the Children's Court is a subdivision of the Family and Children Division of the High Court of Trinidad and Tobago, which is now designed to handle all children matters involving persons under the age of 18 years. The true purpose of the court will be to support the rehabilitation of children who come into conflict with the law. And in seeking the rehabilitation of children, this court also applies principles of restorative justice. This specialized court, Mr. Vice President, aims to treat the needs of this particularly vulnerable group and aims at achieving the best solution for the child and all others involved. And Mr. Vice President, in closing my contribution to this debate, I would like to remind that this government remains resolute in its commitment to effectively and efficiently reform the criminal justice system in this country. The first parliamentary stage in the legislative process has been completed, and we anticipate the concurrent in this House in the passage of this bill to move beyond the parliamentary stage and towards assent and proclamation so that we together can make or take another determined step in the fight against crime. Mr. Vice President, all of us seated here in this chamber, members of this honorable House, we have a grave responsibility to carry out our solemn duty to this nation by supporting and passing various pieces of legislation that would address criminal activity in Trinidad and Tobago. In this context, Mr. Vice President, I thank you.
Good afternoon, Mr. Vice President, and thank you for the opportunity to contribute on this debate on an act to make jurisdiction for criminal matters exercisable in a division of the High Court to be known as the Criminal Division, and to make jurisdiction for criminal and traffic matters exercisable in a division of summary courts to be known as the District Criminal and Traffic Court, and to make provision for matters connected therewith. I am indeed privileged, Mr. Vice President, to be able to contribute on this bill. And the Attorney General, in piloting this bill, gave us his view and the government's view of what I would term the jurisprudential tapestry of where we are in terms of our courts and the administration of justice. And while the Attorney General was very upbeat in his contribution about the hope that we should have that the system will improve, I wish in my contribution to bring us a little bit back to reality as to where we are with respect to our court system, because I am in that system and part of that system on a daily basis. So forgive me if I am not as optimistic as the government, but I think I'm a little bit more in touch with reality. Mr. Vice President, I don't think that anybody here who understands where we are with respect to the administration of justice would disagree with the fact that perhaps for the first time in our history as a country, and it's not something that any one of us should be proud of, is that we are at the lowest point with respect to the administration of justice in our country. The lowest point. And let me start off my contribution by saying that we have a bill here that seeks to create a criminal division of the High Court. And Gerald Ramney, want to put on the Hansard as of today that I want to be able to say, so when it is read 5 years down the road, that this act, this bill that we are debating here, is going to cause absolutely no improvement to the criminal justice system. Absolutely none. But before I get to why it will cause none, I want to answer the Attorney General with respect to where we are. Yesterday I was in the Court of Appeal before the two most senior judges of the Court of Appeal and Justice of Appeal Rajwood, Acting Chief Justice Mendonca, Justice of Appeal Jamada, and Justice of Appeal Raj Kumar. We operate at the High Court, at the Hall of Justice, and have been operating at the High Court in the Hall of Justice without air condition for the last 6 months. For the last 6 months. So when you go to do an appeal or you go to do a trial, we are in the embarrassing position of the judge having to tell you, you can take off your robes. And then you have the embarrassing position of 2 ushers walking in with 2 Lasco fans and putting it at the side of the courtroom. That is the legacy that we have of our judiciary. And putting on the Lasco fans so they could cool the courtroom. But before going further about that, I made a physical inventory, if you want to call it that, of the High Court this morning. And let me precede that by saying this. I had the privilege 3 weeks ago to be a guest of Chief Justice Roberts at the U.S. Supreme Court in Washington. And I've had the privilege also of being at the Judicial Committee of the Privy Council as well. And when you have those experiences, you understand that in developed countries, your court, the place where justice is dispensed, is something that you should be proud of. So when people go to Middlesex Guildhall and see where the Privy Council sits and the United Kingdom Supreme Court sits, they are proud of that. When you go to the U.S. Supreme Court in Washington, they are proud of that, what it represents. So let me tell you how proud we should be of the place that dispenses justice in Trinidad and Tobago, which is supposed to be the Hall of Justice at Knox Street. Let me paint a different picture. On the first floor of the Hall of Justice at Port of Spain, while we want to create a new criminal division and we are hurrahing about how we've just created a children and family division, when the public, because people must understand what justice is, you know. Justice is something, a service that is dispensed to the people. So when the people enter the Hall of Justice and go to the criminal courts and the civil courts, they don't have a public toilet that is working at the Hall of Justice. Not one. I can't go to the female, so I went to the male public bathroom this morning. They don't have a urinal that is working there. So if you want to urinate when you go to the Hall of Justice, you have to find somewhere to do it. That's on the first floor. When you go to the second floor, the toilet is not working there either. And when you go on the third floor, which is where the Court of Appeal sits, there's a big sign, public toilet out of order. But what we should do is create more courts. Right? We should have a toilet unit. So perhaps the toilets would be working, just like how we have all these units here. So then I went to the library in the Hall of Justice on the third floor. And I wanted to photocopy the Judicial and Legal Service Act, which I was preparing for the debate today. But I was surprised by when you go to the law library at the Hall of Justice, there's no photocopier that works either. So you'd have 2 photocopiers there, none working. But let's create a new court, call it the Criminal Division, and let's boast about the courts that we've created. But we can't fix what we have now to dispense justice in the High Court. So, you know, I heard the last speaker talk about all these different units. You must create all these different units. There's a unit at the High Court, at the Hall of Justice, called the Cat Reporting Department. And the Attorney General referred to the fact that we have cat reporters that will give you real-time transcription. The only problem with that is that the real-time transcription can't find itself on a CD because the Hall of Justice have no CDs in the Cat Reporting Department. So I'm sorry that the Minister of Works and Transport, the Honorable Ruan Sinanan, is not here. Because, you know, there are very few times that we compliment the initiative of the government. And I want to compliment the initiative of the Minister of Works and Transport, because when the boat wasn't working, we heard in the other place, the Minister of Works and Transport had the initiative that when he was abroad, he bought a satellite and brought it back to the country to fix the boat. A radar. But you know, what I find very, very disturbing is that there's no shortage of how many trips the people who are in charge of the judiciary make. And nobody has the initiative to buy the part for the air condition to fix it for the last 6 months. And this government is telling us justice is a priority. Justice is a priority to this government. Where today, as I speak, the judges of the High Court that sit in the Hall of Justice are adjourning all their trials. You know why? Because there's no air condition. So one would have thought that if justice was a priority to the government, the Attorney General and the Chief Justice couldn't get together and as a matter of priority, whatever needs to be done, I understand it's 1.5 million. We can't get 1.5 million to fix the air condition at the Hall of Justice. So, well, what I am sure about is that it's less than what we're doing to create the criminal division. And it could be a lot more than 1.5. I don't care how much it costs. Because what we are losing every day by every judge of the High Court deciding to adjourn their trials because they don't have the basic necessity of air condition in the High Court is costing this country and the people of this country more than any air condition. And that is unsatisfactory. You can't be coming here and telling us to create another court when the court that is supposed to be delivering justice on a daily basis, civil trials, criminal trials are being delayed. Not being delayed, being adjourned because the air condition not working. We really serious here? What? I will get to what is going on with the San Fernando court in a short while. Of course, have no fear. The internet is a very amazing thing, I must say. Because I was doing some research. The Attorney General in his contribution, it's on the Hansard, paid tribute to two people who were responsible for the hard work that brought us here, and the creation of this division, and the creation of the Children and Family Court division. There are two people, the Attorney General named them. I'm just going to carry it a little further. The first one was the Court Executive Administrator, who is a critical part of what we are doing here. I'm going to get to that. The person who holds the office of Court Executive Administrator at the High Court, the Attorney General named her, is a one by the name of Christiane Morris Allen. I don't need to tell you who our Chief Justice is. That is the Honorable Mr. Justice Ivor Archie. But I want to ask a few questions of the Attorney General with respect to this Court Executive Administrator. Because, you know, Ms. Christiane Morris Allen is not somebody unknown to Trinidad and Tobago. She shot into the highlight in 2000 when there was a big hurrah about this position that we are dealing with here today, the Court Executive Administrator. And why? Because as we speak today, we don't know the division of labor between the Court Executive Administrator and the Registrar of the Supreme Court, which was what caused litigation in 2000 in this country between Ms. Evelyn Ann Peterson, a very dedicated public servant who gave her life to the judiciary of Trinidad and Tobago, and this woman called Christiane Morris Allen. From the judiciary, when Chief Justice Labastide was there, Ms. Christiane Morris Allen was also in charge of the family division, the family court. What they call the pilot project, the great success of the judiciary is the family court. Everything at the family court is collapsing today, as we speak. But we boast about this pilot project called the family court. This woman, Christiane Morris Allen, was in charge.
I'm kind of waiting for you to tie it in a little bit better to the bill. I will. But just in your references to the individual, because remember there's a standing order that deals specifically with the judiciary and the fact that we don't really bring the judiciary. And that's why I'm allowing you, because the bill deals with the organizational structure of the judiciary. So you're walking a very thin line. Your reference to this woman, you could put it across a lot better in relation to that. You call the person by name already, you're speaking to it because that particular position does also appear in the bill before us. But if you're tying it in, tie it in relatively quickly and just have a little bit more respect in terms of calling the name.
I'm obliged, Mr. Vice President. At Section 3, subsection 1, this Act defines the court executive administrator means the person who is subject to the Chief Justice, is charged with responsibility for administration of the judiciary and heads the Department of Court Administration. That is by virtue of the definition section. By virtue of Section 19, this person called the Court Executive Administrator is going to be given the power to employ on contract for a term of 5 years, but be eligible for re-engagement. That is pursuant to the terms of the contract, on terms and conditions equal to those of a Deputy Permanent Secretary. Those are the powers that are being exercised by Madam Christiane Morris Allen. I would like to ask the Attorney General, because these powers ought to be exercised in an environment of legality, as I understand it. So I would like to know, and I would like the Attorney General to answer these questions. Was Ms. Christiane Morris Allen appointed by this cabinet? And was Ms. Christiane Morris Allen's position of Court Executive Administrator, defined by Section 3 and 19 of this particular piece of legislation, was it subject to any advertisement before she was hired as the Court Executive Administrator? This is a post that is defined under the Judicial and Legal Service Act by Schedule 2. It is required that that person be appointed by the Judicial and Legal Service Commission. So I would like to know that if I am legislating and being asked to make laws to give powers to a person that holds that position, I want to know how they were appointed. Because Ms. Christiane Morris Allen is over the age of 60.
Right. Now that I understand where it is you're going, I'm going to ask you to move forward from that point. If you're dealing with the title as it appears in the bill, right, then I could understand that. But you're dealing with a particular person who's holding that particular title right now. And I'm going to rule that that is not relevant. Deal with the title as it is in the bill, specifically, and leave the person out of it.
I'm very much obliged. I want to go back to the air conditioning at the Hall of Justice, which I think is quite relevant to this debate. Because I have in my possession an email that was sent out to all judges of the Appeal Court and the High Court by the Registrar of the Supreme Court. And I want to read into the Hansard the contents of that email. Dear Honorable Judges and Masters, this is in the circumstances, this is going out to every single judge of the High Court. The people who are going to act in the criminal division too. Dear Honorable Judges and Masters, the situation with the air condition at the Hall of Justice is still being addressed. The acting Chief Justice has agreed to stagger the working hours for staff at the Hall so that no one is required. And listen to this. Let Trinidad and Tobago listen to this. So that no one is required to be in the building for more than 2 hours.
My gosh.
The rostering of staff is at the discretion of the respective supervisors.
Recent time.
So, while we're creating a new children and family division, and while we're creating a new criminal division by virtue of the legislation that we are asked to pass here today, the people at the High Court must go to work and can't stay in the building for more than 2 hours by virtue of the direction of the acting Chief Justice. And we don't think that as a country it is a priority that we fix that. No, we must establish this. So that is the priority of the government. It's still, just like a lot of things they tell us, it come in, it fix in. So we must wait until it fixed for the last 6 months. 6 months.
They're like the Galleon's passage, they're coming in.
But I have hope. I have hope. Like the Attorney General, I have hope. Because the people who are in charge of that building there, called the Hall of Justice, I did a little bit of research, and there is an institute called the International Institute for Justice Excellence. Just like how my friend was referring to the Australian court and the Singapore court. There is also a court. There's also an institute called the International Institute for Justice Excellence. its headquarters are the Hague Business Center, The Hague in the Netherlands. So I wanted to be able to compare what we have here and what we are being asked to pass as this criminal division. I want to see what par excellence there is around the world with these specialized courts. So I went to the International Institute for Justice Excellence in The Hague, and I started to read about them. And amazingly, I started to look at who are the executive board members. And then after doing that, they have an advisory council, which I want to propose we should have an advisory council too in this bill. But in the International Institute for Justice Excellence, the advisory council is headed by one Miss Christiane Morris-Allen. And
honestly, I'm trying to allow you enough leeway to see where you're going to tie it in to what is before us. There's a standing order that deals specifically with the judiciary. I'm going to ask you now, leave the members of the judiciary specifically out of it. We are dealing with a bill that speaks to reorganization of the organizational structure by creating a particular court in the High Court and in the summary courts. Deal with that, leave the members of the judiciary, and anything to do with the judiciary by way of reading out memos or anything like that, leave it out of the debate completely. Deal with what's here in front of us. Thank you.
If I may just clarify, please, so not to run afoul of your direction or ruling, Mr. Vice President, but because I intend to answer some of the matters put on, would my learned colleague please just identify the very last thing he said, which is apparent conflict of interest, a position elsewhere? Is that what I understood? Could you please clarify?
No, the point I want to just answer, let me make the point. I'm just trying to make the point. We are devoting public funds to setting up a new court. This is not gratis we're doing here, you know. This is not generosity here, you know. This is not charity, you know. Public funds are going to be pumped into this institution. When I looked at the budget debates, there is no line item that caters for this. We have not been told what is the cost that is going to be associated with the setting up of this court. There are specific provisions in this act that the last member referred to, and it is clear in the legislation. People are going to be given, and I'm not going to call the name, Mr. Vice President, but under Section 19 of this piece of legislation, the court executive administrator is given the power. We as a parliament are being asked to give that person the power to hire people on contract. That is usually done by the JLSC under the Constitution and the Judicial Service Act. We have been told by virtue of the legislation that this person is going to enjoy the same terms and conditions as a deputy permanent secretary and should report to the court executive administrator. The point I was making that the Attorney General asked me to clarify is not one of conflict. It is one that where we are being told by the government that we must get more from less because the resources we have are not as what we had before, then as taxpayers and as lawmakers, we have a responsibility to ensure that the people of Trinidad and Tobago get what they pay for. And the point I was making that the Attorney General asked me to explain, and I want to complete in one sentence, is that the two people who are in charge of the judiciary of Trinidad and Tobago, the court executive administrator, I'm not calling any names, and the Chief Justice are sitting in The Hague on the International Institute for Justice of Excellence when we can't get that going on here. What they are doing, just not in general, what they are doing there, we want them to do it here. Mr. Vice President, nobody doubts the fact that specialization is something that is good. But at the end of the day, it is not about what is good, it is about what is right. That is what this is about. Can you imagine? I mean, this is shocking that we have a Judicial and Legal Service Commission that is vested with the appointment powers and promotion powers of people that belong to the Judicial and Legal Service. And we are being asked by Section 19 of this legislation to allow the court executive administrator
to appoint a deputy court executive administrator who is not part of the Judicial and Legal Service under the Judicial and Legal Service Act. And when you do that, when we give them that power by virtue of this, they have the power to appoint somebody for 10 years, 5 years, to be eligible for re-engagement for another 5 years. I mean, where is the check and balance in this? The Judicial and Legal Service. So if it is that the court executive administrator is a member of the Judicial and Legal Service that conforms to certain regulations under the Constitution, under Section 141 and Section 111, right? What is the difficulty, or what is the purpose behind having a deputy court executive administrator, but they are not part of the Judicial and Legal Service, and they are not subject to the same terms and conditions as someone in the Judicial and Legal Service? But you want to give them the same powers, or almost the same powers, as the court executive administrator. It makes absolutely no sense. Now, these people who are going to be appointed on contract, who is going to vet these appointments? Cabinet. The terms and conditions. Who is going to appoint these people? You see, Mr. Vice President, the information that I have is that when the Children and Family Division was set up, it was really like a family court. It was everybody family getting jobs down there. That's what was going on. They take it literally. Everybody, friend, fan, family, children, everybody. That was what was going on, because I would like the Attorney General to tell us in his reply, when they set up the family division, how were those people who are sitting there to be appointed? And these people who are going to be put into these units that we have here, well, I have never seen, in my limited experience, I have never seen a piece of legislation that things that are supposed to be administrative have now become part of primary legislation. So we have a deputy court administrator that is supposed to be in charge of the administration of this criminal division. But I don't know what they are going to do, because I understand their job is supposed to be in charge of administration. But we, as a parliament, are being asked to set up a human resource management unit. I mean, how can you have this in primary legislation? How? It's in the what? It's in the Family and Children Division. I know, that's why it's wrong. That's why I wasn't here when they debate that. That's why I get through. Finance and accounting, well, you know what? I want to propose something. When I was looking at that, I want to propose something too. The Attorney General said it's in the Family Division, so we should have it. So let me propose something. You know, in the High Court, they have something called the Marshal Section. Let's amend the Supreme Court Adjudicate Act, and let's put in a Marshal unit. Let's put in an account section, a cut reporting section, an investment unit. Every time this government brings a piece of legislation, and I don't lay the blame totally at the feet of the Attorney General, but the drafting gets worse every single time. I mean, when you look at this piece of legislation, you know, there's one particular senior counsel, not Ms. Choud. There's one particular senior counsel who is very familiar with government rules, that, you know what, looked at this and asked me in the High Court, say, what is this you all really doing with this family and criminal division thing? It makes absolutely no sense. It's going to make no difference to anything. That is really the truth. Because at the end of the day, the court executive administrator is going to hire all these people. You know what this bill is going to do? This is not going to cause, this bill is not going to create a criminal division of the High Court, you know. You know what it's going to create? It's going to create a parallel special purpose enterprise like what we have in Adjudicate and E-Tech, and it's going to be part of the judiciary. Because what this is designed to do is to bypass the Judicial and Legal Service. It's to bypass the Public Service Commission. And you know, the worst part of all of this, whoever is designing the policy behind all of this is this. There are hard-working people who leave Point Fortin to come to the High Court, who leave Sandy Grande and their children at 4 and 5 o'clock in the morning to come to the High Court. To do what? To work as ushers, JSOs, to make the criminal justice, the administration of justice work in this country. They sit there as assistant GSOs, as clerk typists, as part of the public service, and they work for years to get their way up the ladder. And you know what this bill is going to do? It is going to create positions that those people in the public service should be entitled to fill. But they are going to fill that by contract positions. So when you start with 5 O-levels as a clerk typist and work your way up to a steno 4, you know what you're going to find yourself? The steno 4 position or the judge's secretary position is taken by somebody on contract. And think about the disincentive that that is going to have on the people in the public service who have given their lives to the administration of justice. That is what we are doing here. That is what we are doing here. And whoever is behind this policy has absolutely no idea how the administration of justice works in this country. We should understand what is going on in the High Court, what is going on in San Fernando at the Magistrate Court. Look, Mr. Vice President, when do I finish?
Finish at 3:48.
3:48, right. Mr. Vice President, I have 3 notices here, dating back to the 9th of September 2017. Sorry, from the 1st of September 2017. You know what the lawyers in San Fernando were told on the 1st of September 2017? They said the Law Association wishes to notify its members that due to the need to conduct urgent repairs to the roof of the San Fernando Magistrates Court building, the 5 criminal courts will be relocated to the San Fernando Supreme Court building from early next week, and after the 16th of September will be housed at the Medina building on a shift basis until the works are completed. So it's justice by shift. That was in the 1st of September. On the 9th of September, they sent out another memo from the judiciary this time. The public is advised that the building known as the San Fernando Magistrate Court, Old Court, located at the corner of Knox and Harris Street, will be temporarily located to the Supreme Court building, San Fernando, located at Harris Promenade, San Fernando, from Monday, September 11th to Sunday. Listen to this. Is being relocated from Monday, September 11th to Sunday, October 8, 2017. We are in June 2018. This is September 2017. They're still operating justice by shift down in San Fernando. And instead of we devote the resources that are going to be put into this to fix the problems that we have now, that are affecting the administration of justice? No. That are affecting the users of the court system? No. No. The government says no. We must establish a criminal division. So let's establish the criminal division that will sit in the Medina building in San Fernando and leave the San Fernando Old Magistrate Court without a roof. And let us share up the courts in the San Fernando High Court so that the magistrates could work from 9 to 12 and from 2 to 5. Like if it's a junior sec they're running. But that is justice. That is justice. That is the priority of the government. So, Mr. Vice President, you see this thing called the Criminal Division of the High Court, and I understand, right, that they're bringing a probate division too. Yeah, yep. All of this, right, all of this is going to cause the system of the administration of justice in this country to crash. That is what it's going to cause. Jump high or low. I was the one. Because, you know, the minister in the office of the Prime Minister, whenever I hold a press conference at the Hyatt, he always wants to know how I pay for it. I was the one in April of last year who, out of my pocket, held a press conference at the Hyatt to warn this country that the people who are being appointed to the judiciary are going to bring the administration of justice in this country down. And from April of last year to June of this year, we saw it unravel. Unravel before our eyes. And you want to bring a criminal division of the High Court. The Attorney General hasn't for 1 minute, not for 1 minute, this government, this cabinet, not for 1 minute have they told us who is going to provide judicial training and education for the people who are going to staff this court. You know why? Because judicial education and training is not a priority for the government. Let us set up more courts. We have a registry at the High Court. We had masters that were appointed for that children's division of the High Court. You know that they were appointed since September of last year and being paid a judge's salary to do absolutely nothing for more than 6 months? And if we had taken that money that was wasted on those masters, 8 of them, being paid $50,000 a month, we could have fixed the air condition at the High Court. And not a single word. You want to set up a court. Set up a court. Tell you something. I was in the Supreme Court of the United States. Tell you. You know what the priority of the Supreme Court in the United States and the judiciary is? Further judicial education and training. That is why our Chief Justice is at the Federal Judicial Center now, where they train all the judges, every single one, federal and supreme, in the United States. Because they understand that the delivery of justice is a commodity to the citizens of the country. And they understand that the quality and the administration of justice can only withstand public scrutiny when your judges, your magistrates, and your masters are trained. This is not something that you pick up overnight, you know. You don't take somebody who has 2 years experience and make them a master the next day and expect that the administration of justice will improve because you have more masters, you know. It doesn't operate like that. Judging is a science. It is something that you are trained to do. Because you become a lawyer and you are a lawyer for 8 or 10 years, doesn't mean that you can become a judge, you know. That's what we'll be doing 6 months down the road. And that's what you all will be doing, right? Three years down the road when the system crashes. Because you see, this is all a joke. You know what this is? This is a PR exercise so that the government will tell us. They set up a family court. They set up a criminal division. They set up a probate division. But ask the man on the street, who is the person who is accessing the administration of justice, what he thinks about the administration of justice. And all of us will be here, just like the PNM. It's a joke. That's what it is. It is us. It is us who are involved in the administration of justice understands the suffering that people are going through when their cases are adjourned. When they sit for 8 years in the remand and they come to court, and when they reach on a cause list, they tell them, we'll just adjourn for another 6 months. When they're sitting on a capital matter for 8 years and they cannot get a date. That's how it works. And let's not worry about that, because they could continue to sit there. Because you know why? We bring in toilets to the remand section. So we could keep them there for 20 years now. Don't worry to move them out of there. Don't worry about the fact that the DPP office, the average time to file an indictment is for 5 years on a capital matter. When the same district judge, so we change the name from the magistrate, they're going to be called a district judge. It's going to make so much of a difference to the man who's sitting on the remand yard, who's sitting there for 10 years, waiting on the district judge to finish the PI, so that the notes will then be compiled and sent to the DPP, who doesn't have a properly staffed department. So he'll wait another 5 years without bail. That is the administration of justice. And while we're doing that, let's set up another court.
Senator, you have 5 more minutes.
I'm obliged, Mr. Vice President. Mr. Vice President, there is one particular section in this particular piece of legislation, this section 24, where the Rules Committee, established under section 77 of the Supreme Court of Judicature Act, may make rules establishing a special criminal court procedure for the management of cases, types, and offenses referred to in subsection 2, or B, generally for carrying into effect this act. There's something very peculiar about this section, because the Chief Justice, by virtue of section 2, it says the Chief Justice may by practice direction determine the case types and offenses which are appropriate for the special criminal court procedure provided for in the rules of court made under subsection 1. But when you go to section 77 of the Supreme Court of Judicature Act, the person who heads the Rules Committee is the Chief Justice. So it might be very interesting for Trinidad and Tobago to understand, and the Attorney General could explain to us, that the Chief Justice who is in charge of the Rules Committee, by this simple piece of section 24, is going to be able to establish a special criminal court procedure. And the Chief Justice is going to be in charge of determining who is going to be subject to that procedure. I leave that there because I don't want to infringe the standing orders by telling you what that could lead to. Mr. Vice President, 41 years ago, in a case that was referred to in the speech that was written for the Honorable Minister of Labour to read out,
violation of standing orders.
the Privy Council, in Hines and the Queen, gave a warning to all Commonwealth countries that were established under a Westminster model type, like what we operate on, as to the way in which laws are passed. And let me just read into the Hansard what they said. A breach of a constitutional restriction is not excused by the good intentions with which the legislative power has been exceeded by the particular law. So it doesn't matter whether we think we're setting up something good here, you know. It doesn't matter how good our intentions are in setting up a criminal division, you know. If it is unlawful and it is wrong, it is wrong. You can't correct it. And I'll tell you why. I'll tell you why it is so. Because the Privy Council said, if consistently with the Constitution, it is permissible for Parliament to confer the discretion, in that case, to determine the length of a custodial sentence on a particular board, it would be equally permissible to a less well-intentioned Parliament to confer the same discretion upon any other person or body of persons not qualified to exercise judicial power. We are not here on this side concerned with expediency. You know. The government could be as backward as they want with their legislative agenda and could come in May, June, and July of every year and try to rush legislation through the Parliament so they could go on a political platform and say they passed 20 bills and 20 acts. This is another act that has a proclamation clause in it that we have not been told as yet what is the readiness to put this into effect. But they want to come during this parliamentary session to be able to say, we passed 20 laws. The test of all of this, the test in all of this, the unfortunate thing with all of this is that there is only one group of people that are going to suffer as a result of this. It is the people of Trinidad and Tobago who seek to access the justice system on a daily basis. And if at the end of the day, we think that this is good enough for the people of Trinidad and Tobago, and we don't think that it's a priority to fix the problems that we have that plague the administration of justice, that mandates the hard-working judges to work in conditions like what they have at the Hall of Justice today, something is wrong with all of us. I thank you very much, Mr. Vice President.
Senator Choate.
Thank you, Mr. Vice President, for the opportunity to contribute to this debate this afternoon. I wish to go straight to the piece of legislation or proposed legislation which is before us. And I do that because, having read it over and over again, I see that it quite frankly doesn't make sense in parts, and in other parts it seems to be incomplete. Now, as an independent senator, I have supported good proposals brought by the administration when I could. On other occasions, when I see that there are flaws in the proposed legislation, I think it is my responsibility to say so. And I intend to do so today. Now, this piece of legislation does not take into account, or does not appear to take into account, other pieces of legislation upon which it has an impact. Doesn't take into account the Constitution under which judges are appointed. It doesn't take into account the Supreme Court of Judicature Act, which govern the roles and jurisdiction of the judges. It doesn't take into account the Criminal Procedure Act, which talks about what a judge may do in a criminal case. And there are other pieces of legislation which are impacted, but I think those are the most significant ones. Now, if I may just go on to say why I see this as a problem. If we look at Section 5, which says, on the commencement of this act, authority and jurisdiction in all criminal matters exercisable by the High Court or a court of summary jurisdiction shall be exercisable by a criminal court. Well, on the face of it, it looks pretty harmless. But when we look at 4, we see that the criminal division of the High Court shall comprise a court known as the criminal court. So, is it now that the High Court has the power to exercise an additional jurisdiction, or is it that the court of summary jurisdiction, because it is called a criminal court, has the power to exercise that of the criminal court as it is set out? Now, it may be that there's a perfectly legitimate reason for wanting to have this here, but quite frankly, when you read the words, they are not as clear as they should be. So I'm respectfully suggesting that this needs to be explained, because as it is worded, it makes no sense. And when it comes to jurisdiction of different levels of courts, it is significant for us to remember that the Supreme Court of Judicature makes it clear what who are High Court judges and who may sit in inferior courts. We also have to understand that there are different levels of training and experience for persons who sit as judges, for persons who sit as masters, and for persons who sit as magistrates of the court. So we have to be careful that we don't lump all of these people together without clearly setting out what their jurisdictions are, because otherwise jurisdictions may be fudged, and that can have a serious constitutional impact, because persons not authorized to make certain decisions may take it upon themselves to deal with issues such as the right to liberty and so on when they don't have that power. Now, I pause here to say that previous speakers have made much of the fact that, other jurisdictions have so many different divisions of courts and it's streamlining and whatnot. Please let us recognize what we do have. We already have a criminal sessions. We already have the criminal assize. The criminal assize is made up of judges who essentially sit only in the criminal courts. And almost all of them have come from the Office of the Director of Public Prosecutions, or they have been the Director of Public Prosecutions in other jurisdictions. So the question of specialists and criminal expertise needed and so on sort of gives the impression that our judges don't have the knowledge and we need to set up a criminal division to make sure that cases are heard and heard quickly. I defend our judges. I know, Mr. Vice President, you indicated that we should not speak about the judiciary, but I will ask you to grant me the indulgence because I'm not speaking about them pejoratively. I am simply saying that let us recognize that we already have the specialists who are hired and who are functioning in the system. I respectfully suggest that instead of hiving off to form a new division, what ought to be done, and you know, since the 2003 report of the judiciary on delay in the system and how to deal with it and remand court and all of that, since 2003, 15 years ago, the suggestion has been that there must be an increase in the number of high court judges so you can hire more specialists. So you don't need legislation, you don't need, that's not rocket science. That is simply a case of amending the Supreme Court of Judicature Act to permit for more judges to sit and for you to hire more specialists. Now, I also want to let us not think that we don't have other specialist courts. We have the family courts, we have the children's courts, we have the petty civil courts, which is like the small claims courts in Jamaica. We have the coroner's courts. So let us not premise our support or our opposition to this piece of legislation on anything which is inaccurate or stated inaccurately. Now, the other thing that got me a little worried was the apparent disconnect between this piece of legislation and the criminal procedure rules of 2016, which this legislation will have to operate under or use. So this here creates positions of masters to deal with certain matters in the criminal courts. Now remember, a master is someone who is only, well, who may only have 7 years experience, 2 years more than a magistrate. A high court judge has considerably more qualifications to acquire, qualifications and experience to acquire. This piece of legislation, in some instances, is giving the same jurisdiction to the master as to the high court judge. To me, that is a recipe for disaster. Secondly, the only thing that the criminal procedure rules of 2016 permit a master to do is to vet juries, jury selections. So we are setting up a criminal division of the High Court to allow masters to vet juries. Mr. Vice President, quite frankly, this makes less and less sense the more I read. Now, I suspect what happened here. I suspect what happened here is that the initial draft of this legislation may have been tied to the 2013 criminal procedure rules. And I say that because I sat on both committees which assisted the Rules Committee in interpreting and creating the criminal procedure rules. And those rules had dealt with a more powerful role for masters in the criminal justice system. After you went to the magistrate, you would go to the master for the initial hearing, and the master would then have certain procedural functions. So there was a large role and jurisdiction for masters under those rules, but those rules were repealed by the 2016 rules. So they are no longer in effect. And I think, I mean, the resonance of this piece of legislation, quite frankly, reminded me immediately of what was contained in the earlier set of rules, and I feel that that may have directed some of the provisions which have been included here. Sure.
Thank you for your submission. I just ask you, in your thought, if you could address as well how the criminal division aspect as under the family and children division intersects with the argument that you've just put forward. Insofar as masters in the family and children division, in treating with child matters that are criminal in nature, function right now under the same rules, are you saying that those rules are now ultra vires? The 2016 rules? Because it's going on right now.
No. I think, Honorable Attorney General, you've missed my point.
Could you clarify?
What I'm saying is this. This piece of legislation, it seems to me, was crafted at a time when everyone thought that the way forward in the criminal justice system would be guided by what was contained in the criminal procedure rules of 2013, because those rules changed the system radically, and there was a provision for matters to go before a magistrate, then a master, and then a high court judge. And the case management was going to be done by the master primarily. And I think perhaps this is why this legislation affords so many powers to a master, because I cannot believe that we would be creating the position of a criminal court master only to do jury vetting, because that is all that can be done under the criminal procedure rules. Yes, well, sure. It took us how many years to have the 2013 rules? The 2013 rules were never implemented. They were gazetted, never implemented. We came to the 2016 rules, which are sort of operationalized. Some courts are using it, people are getting used to it, and this kind of thing. What are we saying? Simply for the sake of creating a new division and to allow masters to have more powers, we're going to change back the rules again right after people have been educated, and I'm talking about judges, magistrates, practitioners, members of the public, in how to understand and work with the new criminal procedure rules. I mean, this will lead to considerable confusion in the minds of the public. Now, of course, I am just a lawyer, so I'm sure I know very little, and there will be those who will say so afterwards. But in my own bumbling way, let me try to make the points which I think I can manage. If we look at Section 10, this is where we see the difficulty, or the reason for the difficulty that I have. It says, a criminal court master shall exercise all the authority and jurisdiction of a judge which are conferred on masters under the Supreme Court of Judicature Act. Now, the thing is, masters cannot take decisions which affect the liberty of a subject under the Supreme Court of Judicature Act. Criminal law affects the liberty of the subject. So I cannot understand the relevance. I'm sure it is my shortcoming. I cannot understand the relevance of the inclusion of this section in this piece of legislation. Now, if I just jump back a bit, Section 9 says, a criminal court judge or criminal court master shall, in addition to the powers conferred under the Supreme Court of Judicature Act, have all the powers exercisable by a magistrate in criminal matters under any other written law. I think there is a dangerous ambiguity alive in this section. And what it basically says is that the judge has all the powers of a magistrate. So let's put that to work. It means that from now on, a judge will have all the powers of a magistrate hearing a matter in a preliminary inquiry. Let's say this preliminary inquiry is one which has exercised the justice system for a considerable period of time. Does this allow the judge to now say that the judge is pulling that matter before him? Now, it seems to grant the jurisdiction. If the drafting had been with a little more clarity, perhaps I wouldn't be asking these questions and using words like seems, but it seems to create that jurisdiction, but it seems to leave the Director of Public Prosecutions out of the equation entirely. And at the end of the day, the Director of Public Prosecutions and his office, they together play a fundamental role in the system of justice between the inferior courts and the High Court. And there is nothing in this piece of legislation which refers to that role, even remotely. So, you know, everybody wants to fight crime in this country. I do too. I've been the victim of crime many times. But I really do object to anyone suggesting that this piece of legislation is a crime-fighting piece of legislation. I think certainly that's wishful thinking. And let us see things for what they are. If this was going to help the administration of justice, by all means, I would have supported it, because believe me, the criminal justice system needs all the help it can. It certainly doesn't need the ambiguity, the lack of conciseness, the fracturing of this legislation from other pieces of legislation, the inconsistency with, in my view, the judge's function under the Constitution, to add to that pool that we are already struggling with. Now, if I may go to section 13, it says, a magistrate when sitting in a district criminal and traffic court shall be known as a district court judge. Now, please, I think it is simply wrong to call a magistrate a district court judge. Not that they are not excellent magistrates. There are very many excellent magistrates. But let us not let's not do things the way the Americans do it. You know, if you work as a janitor, you're called a maintenance engineer. Let us keep our description of the positions separate and clear, so that members of the public will understand, when I go before a magistrate, this is what I can expect. When I go before a judge, this is what I can expect. The judicial system rests on protocols which are important not only for those of us who work within it, but they are important for the members of the community who come before the courts every day. Sorry? Who are served by it, as Senator Richards has pointed out to me. Now, I also do think, I agree with Senator Ramdeen, and I hope the Honorable Attorney General does not take this in the way that a former Attorney General had once suggested to me when I had objected to a piece of legislation by telling me, if you're not for us, you're against us. Well, in this case, unfortunately, I think I cannot support you on this legislation because it seems to be just a renaming. there shall be in the Judicial and Legal Service a senior magistracy registrar and clerk of the court. We already have a magistracy registrar, so we're adding the word senior. Clerk of the court, clerk of the peace. And what they are allowed to do is basically just an itemizing of what the clerk of the peace and what the magistracy registrar already do. So, you know, I don't know that we are going to be able to fight crime by changing the names of public officers. I don't see that happening, with all due respect. I also found it a little strange that the traffic cases are now essentially taken out of the system because they are dealt with as tickets, unless you want to contest it. Okay, so that means the magistrate's caseload has been lightened by almost half. Why then do we want to increase the judge's caseload by placing greater responsibilities on the judges? The judges are never going to be able to deal with a backlog if the system continues to push cases up at a speed that they can't address. There are currently not enough judges to address the numbers of cases coming up from the inferior courts. So making it faster at the bottom is not going to make it faster at the top. I also noticed that this doesn't deal with the entire court structure, because is it contemplated that we would then have a criminal division of the High Court? I don't know that that would be necessarily a good thing, because informally that exists, but you also have the benefit in important criminal matters of a Chief Justice sitting on a criminal appeal of importance. And unless provision is made for the Chief Justice to be able to sit in on any such appellate matter, then you would lose that benefit. But the Court of Appeal is not even mentioned here. Now, the other thing is this. We're creating all these units to collect money. The Auditor General has said that since 2014, there have been no accounts produced by the judiciary. And this is alarming, because the judiciary was given, and I had applauded that at the time by this administration, the judiciary had been given power and control over its monies. But at the end of the day, if you are given power and control over these monies, and we, the practitioners, are seeing that there's no money for this, and there's no money for that, and there's no money for the other. In fact, no money to pay people traveling allowances, no money to reimburse judges when they fall ill, no money for paper to photocopy, no money for photocopying. There's no money for anything in the judiciary. Well, should we not pause before legislating and say, listen, before we create this division, which will allow a whole set of people to deal with judiciary money, should we not see how the judiciary has accounted for its monies before we take the next step? That is what accountability is for. I don't know, maybe I'm asking too much. Now, I would like us to remember that the court administrator is already a member of, well, is an officer under the Judicial and Legal Services Act. and protected as such. So is the administrative secretary to the Chief Justice. There are certain things which we have to accept are problems for us. Before a joint select committee looking into case management, and the report of that committee was laid in Parliament, and I can speak about it because I'm the chairman of that committee, the court executive administrator, who was not the person who now holds the position, refused to appear before a parliamentary joint select committee, refused to answer to parliamentary correspondence, refused to provide any of the material requested by Parliament. So when you create public positions and you give people this kind of power and protect them and do not make them accountable, then we as a Parliament are to blame. Because that is exactly what happened there. To date, and despite numerous efforts after the inquiry was concluded to still get the statistics which we sought, we did not have the courtesy of a response. Now, I make the point that the relationship between the judiciary and the government is different from the relationship between the judiciary and the Parliament. And if we can have persons flouting parliamentary rules in that manner, I certainly think we would not want to create more positions for that kind of thing to happen. Section 24. Rules Committee established under Section 77 of the Supreme Court of Adjudicate Act may make rules of court. Fine, they already do. In fact, I think the section says that when the Chief Justice makes those rules, when we see that the Chief Justice is to make rules under that section, what we really mean to say is that the Rules Committee must make the rules, or something to that effect. I'm sure that Senator Simonet will correct me if I refer to it incorrectly. But what exactly is a special criminal court? Because this is what the section says. The Rules Committee, established under Section 77, may make rules of court establishing a special criminal court procedure for the management of case types and offenses referred to in subsection 2. It goes on to say, Chief Justice may, by practice direction, determine the case types and offenses which are appropriate for the special criminal court procedure. Well, what is this? We legislating in the dark here? Because what is a special criminal court? Where does that exist in our criminal justice system? Is that a new creation, and what makes it special? Or who will be the special ones? I ask myself. But those are just questions which perhaps the Honorable Attorney General can answer. Now, the other thing that worries me about this is you created a special criminal court procedure. And you are saying the practice direction by the Chief Justice would determine what case types and offenses are appropriate for the special court procedure. But surely we need to be able to know what kinds of cases are being contemplated here. There is absolutely no indication of what is likely to fall under this category. So I don't know how we can support legislation which lacks those specifics. And what would be the criteria used for these special procedure rules to apply, and for this practice direction to apply to these special procedure cases? Now, I see the Attorney General looking at me. Would you like me to give way, Honorable Attorney General?
It's clear that I'll have to do a more fulsome reply, and I don't mean to cut into your time. I'm trying to understand the reference to special criminal court procedure, simpliciter. Is it that you're saying that you wish to have a prescription for a special criminal court as opposed to procedure, and that there should be a scheduling of the types of matters now that could perhaps populate the consideration of that procedure which the rules may prescribe? I just want to get some clarification on that.
Well, I think, absolutely, I think this is entirely insufficient. I don't know of any special criminal court.
Well, that's not what the law says, the bill.
This is creating a criminal division of the High Court.
Yes, but we're talking about a procedure.
Yes. Well, what makes it special is really my question. No. Well, then we are talking about handing out discretions to public officials in breach of the Constitution. We are saying that, listen, the Criminal Procedure Act, well, I'm answering you, if I may, through you, Mr. Vice President. The Criminal Procedure Act governs how cases are dealt with in criminal courts. That's one thing. So you have primary legislation. Then you have secondary legislation via the criminal procedure rules made under the Criminal Procedure Act. And those rules are of 2016. Now, that legislation and those rules conform with constitutional requirements and due process requirements and that kind of thing. Now, we are simply saying here that there is going to be a special criminal court procedure, and cases are going to be pulled and, forced into that procedure. Well, tell us what it is. Why should it not be set out? With all due respect, Mr. Vice President, it's very difficult to speak when there is a chatter in the background, regardless of where I'm speaking. And I am simply saying that there is nothing here to tell us what that means or how that is going to operate in the context of the Criminal Procedure
Senator, you have 5
Act
minutes.
and the criminal procedure rules which govern criminal procedure in relation to criminal cases. It is as basic as that. But then again, I probably know very little about these things, and I'm sure I'll be enlightened by later contributions. Thank you for the opportunity to speak.
Senator Seminet.
Thank you, Mr. Vice President, for the opportunity to contribute on this important bill. I've listened to my learned friends on the other side, and whilst Senator Choate has raised one or two items of some concern, which I will address, I think it important to place into context the framework of the legislation being proposed by the Honorable Attorney General. We all are aware of the slow pace of criminal justice in Trinidad and Tobago. And it is not a question of simply accelerating cases, speeding up the process, or as trite as notching off another bill transformed into an act of parliament to inform some one or other platform around the country. We are in this country in the grip of wanton criminality from top to bottom. It is very clear to even the most junior of our citizens that there is no or little regard for implementation of the law, whether it be traffic laws, simply about the regulation of parking or the speeds at which cars drive, the lack of traffic signals given to regulate traffic on the road to avoid vehicular accidents, to the complexities of the criminal acts of burglary and assaults and so on. What this bill seeks to do is to channel the administrative treatment of the implementation of the criminal law so that the force of the law is once again respected, so that it is a very different exercise to that involves the fixing of air conditioning or the repair of rotten roofs, which incidentally did not start rotting on the 15th or the 9th of September 2015. These are problems that have been ongoing for quite some time. So to distract the population with notions of mere incompetence of the government or the Attorney General in dealing with such matters, drawn against the exercise of streamlining the management of criminal cases so that they are dealt with, disposed of, and generate some degree of respect for the law, is, in my view, the importance of this piece of legislation. Should not be confused with the similarly important but not as important regulation of the airflows and humidity in the High Court. So that the bill being advanced by the Honorable Attorney General and the government is for the creation and establishment of a criminal division of the High Court on the one hand, and a traffic and criminal division, district criminal and traffic court on the other. In the first instance, it clearly provides for a criminal court management system that would allow for the judges of that court to treat with and deal with preliminary inquiries as well as summary offenses, and to streamline those in a manner that increases the rate at which criminal justice is dispensed. And nothing could be wrong with that, Mr. Vice President. If we are serious about addressing the issue of crime and serious about the issue of lifting the citizens' respect for the law, compliance with the law, and overall well-being of the society, we would all join in supporting the legislation. So that I take a different approach entirely to that of Senator Ramdeen, my friend, who seems to be committed to building administration issues as opposed to looking at the guts of the criminal justice administrative arrangements aimed at transforming them for the greater good of society. No doubt, those who are in charge of the day-to-day maintenance and day-to-day administration and workings of the court will heed Senator Ramdeen's discomfort and seek to ensure that when next he is at the High Court, he feels cool, calm, and collected, so that his contribution on the next item of legislation aimed at improving the administration of justice will in fact benefit from his considerable, though admitted, limited view of the matters. I think it important as well, Mr. Vice President, to indicate that the exercise contemplated by fixing the administrative arrangements, including special rules, is not a new embarkation. I myself was at the forefront of the arguments which sought to test and to weigh the negative effects of the then advanced new civil proceeding rules. We were able back then to obtain important concessions, but we were also aware back then that much needed to be done to have improved the rules governing civil proceedings. In relation to what the Attorney General is proposing in this legislation, there is no suggestion that the existing structure of the rules be dismantled in toto. What Section 24 seeks to do is to give to the Rules Committee, which is chaired by the Honorable Chief Justice, the power to make rules that assist in the better administrative arrangements contemplated by the special divisions of the criminal division as well as the district criminal and traffic court division. I do not agree with my learned friend Senator Choate that that section, that is 24, or resort to the Rules Committee, has an automatic effect of transgressing the Constitution or denying any citizen the enshrined rights of being heard or to representation before a court of law in this country. The rules contemplated are clearly rules that are aimed at administrative procedure, not at substantive access to justice. I believe that such a concern is, with respect, a little misplaced. In relation to the issue of financial controls, I can agree with Senator Choate that without doubt the judiciary has an obligation to render proper accounts and to comply with directions of the Auditor General. I cannot, however, see how arrangements made in this bill for the creation of the criminal division can impact upon, as it were, a license to the judiciary or to the members of the special division to engage in financial mismanagement and non-compliance with proper record keeping and accounting. That's a separate issue. It is an important issue, but it is an issue that obviously needs to be treated with in its discrete area of oversight. It does not affect, in my respectful view, the liberation given to the system as created by the provisions at Section 4 and Section 12 of this bill. It goes without saying, Mr. Vice President, that we have tinkered with the systems for many, many years. We've sat on the sidelines and criticized both the magistracy, the laws that are intended to deliver a regulation of a certain behavior that guarantees the protection of the wider citizenry. But we have done little to intervene with effect to improve the criminal justice system. I think that this bill seeks to achieve just that objective, and that it does achieve that objective. The engagement of further administrative staff under the bill and under the direction of the court executive administrator does not derogate from the structure being advanced of liberating the magistracy of the endemic and chronic paralysis it is in. My learned friend, Mr. Ramdeen, has made the submission that the arrangements have the likelihood of depressing existing public servants in the system. And I couldn't disagree more in that those existing office holders continue in their function. What is being created here are additional positions for an additional and expanded service to be offered in the criminal justice arena, so that the chances or the opportunities for those currently employed to either be promoted or to advance themselves by further education cannot be impaired by the creation of these positions. They are not intended to displace anyone, nor are they intended to operate as a disincentive to those who seek to do better for themselves. I think that that concern is informed more by a predilection to alarm than a predilection for structuring and advancement. My learned friend, Senator Choate, also indicated that she found that the rules the roles and jurisdictions of the judges and magistrates were being blurred. And again, I with respect, must disagree with that position. A criminal court judge or criminal court master would obviously be engaged under the standard qualifications that are required at this point in time, so that the experience and qualifications of such persons are not being in any way interfered with by this bill. The blurring or apparent blurring of the jurisdiction of the master and the judge, as indicated as indicated by Senator Choate in her reference to Section 10, is again, in my respectful view, not entirely correct. As we well know, in the civil arena, the master exercising the jurisdiction of a judge does so competently in the area of assessment of damages, of deliberations on cost, and so on. What Section 10 of the bill achieves is a greater facility for there to be the management of cases by masters, and therefore the ability of the court to deal with more matters and the unburdening of the judges who at this point, or who otherwise would have had to have dealt with all matters, so that it is a freeing up of the case load and a more judicious, if I could use that word, distribution of the load as between the criminal court judge and the criminal court master. I don't think that we need to be concerned that someone will be unaware of what powers the master has to exercise as to what the judge has to exercise. It's merely permitting for a more equitable caseload distribution, in my respectful view. I was once told by a literature teacher at high school that a rose is a rose by any other name. And so again, if the magistrate sitting in the district criminal and traffic courts is called a district court judge, I couldn't see why, after some passage of time, possibly a month or two, citizens...
I think the offending senator has already left. By now, every member knows what happens when devices go off. So I just give a reminder at this point to please check your devices as the member is making his contribution. Just make sure they're on silent.
We like to hearken to our colonial vestiges, and accordingly, in the English tradition, we are not inclined to sugarcoat the descriptions or the manner in which we identify an office holder. So whilst I join Senator Choate in not engaging in sophistry by calling the housekeeping engineer a housekeeping engineer and the likes of that, I can see no good reason why a magistrate sitting in the district criminal and traffic court can't be called a district court judge. I don't see that that blurs or interferes with any commonsensical understanding of who one appears before in that court. We need to move forward and to concentrate on the more fundamental elements of the bill that seek to get our criminal justice system moving, and with respect, whether we call the district court judge a district court magistrate, or district court judge, district court ombudsman, is neither here nor there. It's a question of the function being performed by that office holder. The other criticism made of the other criticism made by my learned friend, Senator Choate, which is the, going back to the rules, one has to recall that the family and children's division rules are no different. They were voted on and approved by the opposition. And it is the same structure being proposed here without any deviation, so that it has worked in that context, it can work here with respect. Senator Ramdeen referred to the collapse of the family court, and I heard no specifics given as to what information supported that statement. But from my recollection of events, the family court and children's court has not collapsed. I think that is alarmist, and it is untenable to make such statements without any supporting statistics or information. Mr. Vice President, the bill at Section 18 indicates that certain administrative departments of the criminal and traffic court are to be established. And those administrative departments of the criminal and traffic court are logically set out here and are intended, yet again, to aid the efficient management of that court. And as many of us know, we attend from time to time the Magistrates Court on St. Vincent Street. And when you go to the first court, I believe it's the first and second court that deal with traffic matters, there are hundreds of cases on a daily basis just being adjourned, as the records are not, either the records are not to hand or the police officers are not to hand. So that where you have an administrative arrangement that is seeking to treat with these offenses efficiently and you're creating units of the court to treat with them. It is not a question of creating unnecessary departments. It is a focused and definitive intervention to ensure that the magistracy, as it exists today, is unbundled of these hundreds of cases that can be dealt with more efficiently otherwise. And that takes me to the issue of permitting for video conferencing and treating with attendances by other electronic means. I think that is at section it's a provision allows for telephone conferencing and video conferencing, Mr. Vice President. I think that has proven to be of tremendous assistance in the civil arena, where cases in Tobago have been able to be dealt with in Trinidad, cases in San Fernando have been able to be dealt with in Port of Spain, and vice versa, as the judges move around the different courts. So that what you have is a body of arrangements intended to dramatically impact on the delivery of criminal justice on the one hand, lifting of the respect for the law on the other, and in relation to minor offenses, traffic offenses and the like, fines and so on, a procedure whereby these penalties can be administered, and by that money is collected and offenses dealt with in a manner that creates space for judicial time to be better used on more serious matters. And the Attorney General, with respect, can only be complimented for that intervention. It ought not to be reduced to a comparison of what building arrangements and building management arrangements are made for the judiciary. Those, no doubt, will be attended to, but we must treat with the fundamental core of backlog, the fundamental impediments to criminal matters moving forward with expedition, which will only lift the respect for the law and lift the rate at which criminal activity is reduced in this country. So, Vice President, I thank you again for the opportunity to make a short but intervention on this bill. Thank you.
Senator Sheikh.
Thank you for recognizing me, Mr. Vice President. Firstly, I'd like to thank the Leader of the Opposition for giving me the opportunity to serve. And I'm very grateful for the warm welcome that I've received here today in this Honorable House. It is my privilege to contribute to the debate of this bill, the Criminal Division and District Criminal and Traffic Courts Bill 2018. I was called to the bar in 2008, and I have practiced almost exclusively in the criminal jurisdiction. It has given me a working knowledge of the problems that plague the criminal justice system and allows me to apply that in particular to this bill. The Honorable Attorney General indicates that the intention of this bill is to, 1, treat with the formalizing of the structure of the court, 2, to model a criminal division after the Family Children's Court division, 3, the flattening of judicial administration, 4, merging jurisdiction between high court and summary courts, 5, to quicken justice, and 6, to allow for the operation of specialist courts. Mr. Vice President, I agree with the Honorable Attorney General's position in his contribution that the criminal justice system has come to a grinding halt. I agree with other members who have spoken today that the pace of justice needs to be quickened. There is need for significant improvement. What I do not agree with, however, is that this bill deals with any of that. Mr. Vice President, the overall hope that this will assist in fighting crime is misguided. The reality is, the criminal justice system is a small part of a much bigger problem. We've had statistics put forward today, Mr. Vice President. 17.95% crime detection in 2017. Between January 1st, 2013 and December 31st, 2017, 2,190 persons were murdered. 2,190 persons, Mr. Vice President. Of that number, the statistics say 391 have been solved. That shows a very real problem that exists with crime detection. Why are we not bringing bills to deal with that? Time permitting, I propose to deal with the intentions that this bill is supposed to treat with. The first area I want to deal with is to quicken the pace of justice, which is perhaps the most important area. Because at the end of the day, everything that we're trying to do with any piece of legislation is to improve the working of the criminal justice system. We need the criminal justice system to work faster because it's an it will be an active deterrent to crime. We need persons who are contemplating criminal activity to know that they will be met with consequences, swiftly and with certainty. We need the accused to go from charge to trial quickly so that, should they be vindicated, they have not been schooled in crime during their incarceration. But should they be convicted, that they would move from remand yard to convicted parts of the prison where they can avail themselves of rehabilitation programs, so that if and when they come back out into society, they can actively contribute. This reduces the rate of reoffending. That is why we needed to move faster. The reality is the criminal justice system is overwhelmed due to delays in a multitude of areas that are not dealt with in this bill. This bill, Mr. Vice President, is no more than an administrative fix for a non-administrative problem. Mr. Vice President, this bill is taking what we already have and calling it a different name. It is making distinctions without a difference. Senator Choate did go through some of these, and I will go through it very quickly. Clause 4 provides for the establishment of a criminal division. We already have that. Clause 6 provides for the prescription of sittings of the criminal court. Again, we already have that. Clause 6.2 proposes the means to conduct hearings by video conference. This already exists. Clause 12 provides for the summary court to be known as the district and criminal traffic court. We're already renaming courts. We already have a traffic court. We already have magisterial courts that deal with criminal matters. Clause 18.2 proposes the creation of a number of units, nearly all of which exist in some form already. The one unit that does not exist, though, Mr. Vice President, is the Witness Support Unit. There's a reason for that. The court is supposed to be an impartial body. The court ought not to be involved in any way in dealing with witnesses that are in matters before that court. The police service has a witness support unit. Those are the areas, that is the proper place to deal with this.
Come and take some notes.
It does absolutely, this bill does absolutely nothing to decrease the time that it takes from charge to trial, or to decrease the time when the actual trial starts. The length of the trial is not affected by this bill. And I should use the example of a murder charge in this case. When a person is brought before the court on a murder charge, their first port of call is the magistrate's court. The delays that occur in the magistrate's court are substantial, but they are not addressed in this bill. The first step at the magistrate's court is the commencement of the preliminary inquiry. For the benefit of the listening public, this is where it's determined if there's a case to be tried at the High Court. The preliminary inquiries currently take, which is in the form of paper committals, they currently take 6 to 8 years from start to finish. No clause in this bill addresses that. The paper committal was brought about to reduce the time of committal proceedings before the court. Prior to paper committals, what we had was viva voce evidence. Persons would go into the box, they would give their evidence, and then they would be cross-examined. That used to take, on average, a year. Now, the paper committals were supposed to reduce that year. Instead, it's done the opposite. What happens now is that we're dependent on the police service to file, to collate, prepare, and get to the DPP's department statements to be filed. This takes years. There are matters in the magistrate's court that come every 28 days and not a single witness statement has been filed. This bill doesn't deal with that. Even with the introduction of the criminal procedure rules that is meant to help with the expediency of justice, there is no effective method of sanctions. So the reality is, all of this goes unchecked. The delays continue. The police officers are either overworked or unconcerned, and the DPP's office is understaffed. The director has said that publicly. What was just actually raised, and I had also make reference to it here, there are continuous adjournments in the magistrate's court. In the 8th Court in the Port of Spain Magistrates Court, which deals primarily with murder charges, half of the morning is to adjourn matters. That's precious judicial time being wasted. Even with the criminal procedure rules again, you cannot force police complainants to appear. You cannot make them speak to witnesses and ensure that they're available before the court. And you cannot do more than one trial at a time. None of that is addressed in this bill. Once the committal proceedings are complete, the next step is to file the indictment. This was raised by Honorable Senator Truitt. It takes a long time. It takes a long time because the DPP's department simply does not have the resources. Clause 18.2 proposes the creation of a criminal court information communications technology unit. It's quite a mouthful. To provide transcriptionists as one of its solutions. This already exists in the current system, but more transcriptionists won't hurt. But is that going to solve the DPP's problems? Is that going to make indictments come any faster? No. When the indictment is finally filed, we go before the High Court. The matter is put on what is known as the cause list, and it's the first stepping stone in the case management process. The Honorable Attorney General, through this bill, proposes that the master will help with case management and so speed up this justice system. Case management alone will not solve that problem. The administrative provisions in this bill does not address the prisoner transport system that is always late. Court is supposed to start at 9 a.m. 10:30 a.m., we are still waiting, twiddling our thumbs, because they are not there. Mr. Vice President, this bill does not address the fact that delays occur in trials due to the fact that accused are either unrepresented or simply that their attorneys are in other trials. And I raise this because it's important. Persons in the criminal justice system, the vast majority of them are poor. They don't have money to afford attorneys. They depend on the legal aid system. Do you know how many people want to do legal aid? Not very many. Attorneys are not willing to do it for a number of reasons. You start a matter, supposed to last a week. It takes months. You are paid a fixed sum. You end up working for less than minimum wage. It has been often said that legal aid is not supposed to be a means of income for attorneys. We agree. No attorney wants to live off of legal aid. But when the accused persons have this as their only option, they should be given the opportunity to be able to have attorneys. Which brings me to the next point. With the introduction of the criminal procedure rules, all the work is front-loaded. All the applications are front-loaded. You do all of the work up front. You're not compensated for that. Should that matter, should you not continue on any matter, if you're fired by the accused, or if your appointment is revoked for some reason or the other, for example, you're doing a trial in another place and the court is ready to start, you have completed all the work not to be reimbursed. Do you know what? The reason why this happens is because the act that governs legal aid does not contemplate the criminal procedure rules. It does not contemplate the fact that all of these things are being done prior to a trial actually being started. So most persons, most attorneys say, you know what? I'm going to go elsewhere. I'm going to go in the family court. I'm going to go in the civil jurisdiction. The person suffering from that are the accused. Why don't we bring legislation to deal with this? We have heard about the Public Defender's Office. That's a better use of the resources that are going to be allocated towards this bill.
Correct.
Mr. Vice President, the bill contemplates masters conducting CMC, the case management, to speed up the case management system. But let's be real. You have about 20 odd attorneys that has been thrown out that actually doing legal aid, actually doing criminal matters. Criminal matters go from day to day all day. How are they going to run from their matters to another court to be able to do the case management before the masters? A certain amount of practicality has to be applied when one is considering provisions. Because it sounds good on paper doesn't mean it could work. The current system that we have where CMCs are allocated for 1 day per court actually works for the dynamics of how the court is working. That's what it works right now. The bill does not deal with delays caused by the state. Not being ready, not having the police complainants available to actually speed up the matter so that they know that they're ready. Yeah, state councils not being appointed, state councils being overworked. I believe the last figures were something as about 115 matters being assigned per state council. That's an enormous amount of matters for one person to handle. They cannot possibly do all of that and make this justice system work well. Even with the active case management, you reach to court only to find out a witness is not available. This act doesn't deal with that. It doesn't provide any kind of mechanism to actually deal with plea bargaining on any real way. Yes, you have the piece of plea bargaining legislation. How often is it used? We have persons who sit before the courts time and time again, sitting in jail for 12 odd years. They haven't had a first trial yet.
No bail.
These are murder matters. There is no bail. They are sitting, waiting. And then on top of that, some of them are only now being told, you know what, we'll consider a plea. this bill doesn't deal with that. Instead, what is happening is that these prisoners who could have pled guilty, go into rehabilitative programs, come back out if necessary, or go and deal with their sentences, they are being forced to choose to look at maximum sentence indication. Maximum sentence indication is when you ask the court, if I plead guilty, how much are you going to give me? You'll get a discount for pleading guilty, and then they consider the facts. The justice system is not supposed to work in a way where persons feel forced to plead guilty to get out of the system. What is going to happen? You have the real perpetrators walking outside. That can't be right. Those persons who plead guilty have a criminal conviction attached to them for the rest of their life. That's a serious, serious thing. As I said before, this bill doesn't deal with the fact that the court could only hear one matter at a time. There are 6 criminal courts in Port of Spain, 3 in San Fernando, 1 in Tobago. Matters that take a week take a month. Should take a week, my apologies. It takes a month. No amount of case management speeds that process up. We need legislation to speed up the trial process, not to deal with administration on the outside. We've had even a number of pieces of legislation that have been put forward that deal with bad character applications, for example, or applications that you can put in place if you can't find your witness. But the reality is, those things don't happen until you reach trial. So when one looks at what it takes from charge to trial, the reality is that this bill is an administrative bill. And it doesn't do anything for the real delays. It will do exactly what the long title of this bill suggests. It changes what things are known as. What the bill will do, however, is add an additional burden on the taxpayer. Our present infrastructure in the court system does not allow for housing of all these additional units and staff. We will need new court buildings or additional buildings to house them. New court buildings and outfitting of these buildings take time and money. If they are housed elsewhere, you're defeating the purpose of streamlining, of having everything in one place. Instead, the same resources that are being used for this administrative units and administrative staff should be used and refocused on the creation of more courts so that we can have to clear the backlog, to actually do something. When we live in times as these where resources are finite, you need to choose to use it wisely. It should be allocated where it's needed the most. Mr. Vice President, the proposed Part 4, Clause 18 establishes the Criminal and Traffic Administration Department. It's meant to be linked. There's a certain level of complexity that's required. You have 13 magisterial districts operating within Trinidad and Tobago. They're not all located in Port of Spain or San Fernando or capitals in Tobago. How exactly? The bill doesn't speak to how it's going to work. If you are collating everything and putting everything together, how in reality is it going to work? Even provisions in this bill, Mr. Vice President, which at face value is intended to improve the efficiency of justice, doesn't do that. Let's look at Clause 6.2, the conduct of hearings via telephone. That's contrary to the rights of the accused. This clause does not preclude ex parte hearings. It doesn't speak to it. An accused has the right to be present for every matter concerning him. I'm highly doubtful if he's sitting down in remand yard that he's on that telephone conversation. The only things that are done ex parte with criminal matters usually happen in the investigative stage, wiretapping, search warrant, or afterwards when they're discharged for a judge's warrant. Not during. It even brings challenges to the attorneys. How are they going to protect themselves when you're on a telephone conversation and the accused wasn't there? conduct of attorneys is a real ground of appeal. There's even more to look at. There's a reason why fitness to plead is so important. It's not only that the accused person should know what they are pleading to. It is that they should understand everything surrounding the matter, that they're able to give instructions. When a man's life and liberty is at stake, he has every right to be part of the proceedings. Which brings me to the next area, the merging of jurisdictions. Mr. Vice President, there's always been a reason why they're separate. The matters that lie in the High Court deal with serious matters that lead to a loss of liberty as its punishment. Some of them do not allow for bail, such as murder, or they can be denied bail due to the seriousness of the offense. Summary court matters, on the other hand, deal with less serious matters where bail is usually granted, and where options like reprimand and discharge exist. That don't exist in the High Court. The merging of these two distinct jurisdictions is contrary to the intention of what was put in place when they separated it to start with. The Honorable Attorney General stated that one of the reasons why they are looking at the merging of the jurisdictions is that the intention to abolish the preliminary inquiries. It would allow for the matters to be moved from the Magistrates Court to the High Court, where it's proposed that the master should be able to deal with it. Based on the figures that were provided to us, we're talking something in the range of over 30,000 matters. Right now, the figure before the criminal courts, as provided to us in this debate, stands at approximately 2,000 as of March 31st, 2018. 2,000 matters in our criminal courts currently, and we have people waiting for trial for 12 years. How is 30,000 matters going to be transferred for them to deal with? It wouldn't come to a grinding halt. The criminal justice system will stop altogether. Even with the proposed increase of judges and the use of masters, they cannot deal with that type of numbers. You are adding more problems to a burdened system. One of the other things that is proposed in the master, with the use of the master at the criminal division, is in clause 9, that they can deal with indictable matters. Are they going to be offered the option to have a judge with a jury? It doesn't say in this bill. How is this bill meshing with other pieces of legislation that protects the accused's rights? One of the things under the Supreme Court of Judicature Act, Section 65C1, a master can be appealed. Are we not adding an extra layer here where we can have more delay due to appeals? This is not speeding up the criminal justice system. Which brings me to the belief that it is to model after the Family and Children Division. The Family and Children Division, working court, they too are overloaded with matters. When they first started, it took a month maybe to get a matter. Now it takes many, many months to get a matter listed. Because you create courts does not mean that you remove the numbers. It doesn't necessarily make it speedier. Not to mention that there are several differences, key differences, between the family court division and the criminal courts. I could even lump family and civil together. The family court deals with private litigants, whereas litigants are brought by the police before the criminal courts. The family court system, they really suffer situations where they're going to be incarcerated. Whereas, in the criminal courts, murder clients, automatic incarceration until your matter is heard. The criminal courts depend on security systems to bring the accused to court. The family division do not have the sheer number of police and civilian witnesses. They don't have voluminous matters that take months and years to complete. The litigants in the family court file all of their paperwork up front. They can go to mediation. They can settle key matters so that it's very narrow issues of law if and when you go to trial. Can't mediate in the criminal courts. And you certainly can't give any mutual undertakings. The trials in the family court last, on average, 3 hours. Very rarely more than a day. Criminal courts go day to day and months. So to expect that the Family Children's Court Division can be used in the criminal courts is simply wanting the impossible to happen. You cannot compare apple and oranges and say because it works in one place, it will work in another. It doesn't work that way. One of the other areas that was dealt with is the formalization of the structures of the court. Why exactly are we formalizing the structure of the court? The way that the court is working right now bears very little difference from what is proposed in this bill. The proposed bill at clause 10, 13, and 15 establishes new positions. It doesn't set out any terms and conditions. But for the most part of it, this bill deals with name changes. What this bill needs to do is set out exactly what these new persons are going to be doing. How is it going to apply? Because there are very real concerns in the criminal courts. You're dealing with deprivation of liberty. That's not anything to be arbitrary about. You can't have vague clauses and expect that it is going to work well. Which brings to the operation and the concept of the specialist courts. Clause 24 allows for the Rule Committee to make rules to establish special criminal court procedure. It's meant to provide for the operation of the specialist courts. This whole area is very vague as to how these courts are going to apply, what are they going to apply to. And really and truly, if rules were going to be made to govern procedure in any of the criminal courts, you didn't need the legislation for that. But even so, specialist courts are not going to be the solution for the delays. Specialist courts won't make the forensic work any faster. The reality is, there are matters before the magistrate's court right now where you are waiting for the forensic to tell you that is a gun. Years. Why are we not spending our resources on adding more staff to the forensics if that is what is needed? Specialist courts are not going to help the police detect any crimes any faster. It's not going to make them do it any better. They need help. Where's the technology? Where is the training? We can spend resources towards that. Instead of creating all of these administrative posts that we're going to be looking for places to house them, giving them salaries, all of that is money that can be better used. Let us improve what we already have. We can make what we already have more efficient. We can invest in more courtrooms. We can invest in actual tangible items. Much was made about the air condition, but that's a real problem. All of the parties concerned in the courts need to be able to function. So we are sending people, the prisoners, back down to remand yard because it's too hot to deal with their matter. Is that fair to them?
There ain't no big problem.
These people are being deprived of their liberty. None of us would like that for ourselves. So don't say that the air condition has no effect. It does. Every day with your liberty denied is a day too much. One of the things that was raised today as well was that we have situations of domestic violence. We have protection orders being granted that don't actually protect. We have persons, unfortunately, becoming victims because this does nothing for them. Let's train our police officers how to deal with it. Let's put some active mechanisms in place. Let's use our resources wisely. As I wrap up, I, for one, as an interested party in the court, would love to have any piece of legislation that could assist us. But the reality is, this one doesn't. So I hope that my comments would be taken and that we would actually be in a position to bring legislation before this House that would help to speed up the criminal justice system. I thank you, Mr. Vice President.
Honourable Senators, permit me at this time to congratulate Senator Sheikh on her maiden contribution. At this time, we will take the tea break. So, this House will now stand suspended until 6 p.m. for the tea break.